Welcome. We are continuing with the values of the Constitution of India. Concept wise, we are conceiving a project to have a visit to Haryana State Judicial Setup, its values in reference to the aspects and features and events pointed out in the books of Justice S.D. Anand. Today, the specific point of attention is being drawn to the proceedings in camera, proceedings on camera, proceedings within camera. This new norm, because of corona or because of the technological breakthrough and having virtual hearing procedure, there is a need to revisit the hearing procedure, the right of hearing. There is a need to revisit as to the courts being open, what will be its effect upon the virtual hearing, whether a third party or public in general can in any way exercise his right to know what proceedings are taking place in a particular litigation during particular hearing. The existing provisions of hearing in open court in physical presence form is a situation which is much different than the situation caused, created, and being accepted as a virtual hearing. Courts are open and still in specific situations, proceedings can be held on camera under the orders of the court with the permission of the court. Even otherwise, though the courts are open, but the physical limitations of the space available in the court, etc., court has got the powers to restrict the presence of persons from public or particular number of persons, etc. The concept of proceedings on camera in fact means the proceedings being held not in open court, which practically would mean that anybody else other than the parties can be present during the hearing. So proceedings on camera in practical terms comes to be proceedings in privacy from the general public. Only the litigants, the concerned persons, the parties to the litigation can be present during hearing of trials of such litigations. But the word camera in a way means having a record of it. The concept in which we take proceedings on camera would mean the whole proceedings are being recorded. Now, whether such recording will be part of the judicial record, whether such proceedings records can be availed for appreciation or otherwise, whether such camera records will be part of the judicial record and same can be referred during appeal or otherwise in different connected proceedings. These are the situations, these are the aspects in the background of which we shall consider the steps initiated for having cameras in courts. Cameras in courts will be a new norm. This new norm of cameras in courts, all proceedings in courts to be recorded in camera. This, in a way, is a qualitative difference in the right of presence in the open courts. It is like having a telecast. It is like the legislative assembly, parliament's proceedings being recorded and being telecast and being visited, being seen, being heard on television. It is this feature, it is this value, it is this norm which deserves to be debated. This deserves to be revisited, whether there shall be cameras in courts or not is the prime question. And then if cameras are to be in court and the attended question will be what is going to be the evidential value and other legal aspects of such records. The provision of cameras in courts means all proceedings, all judicial proceedings, the entire trial in court is to be recorded, and the records will be the judicial records. Records will be preserved. Records will be subject to the public inspection. Record will be like other judicial record. Once the proceedings on camera become part of the judicial record, the same is having very, very wide implications. The connected aspects are that the entire environment of the trial will get recorded. The entire steps taken will be recorded. The procedural steps will be recorded. The conduct of all the parties concerned will be recorded. Now, such record is having many implications. On the positive side, it can be said that it will facilitate to have full appreciation of every detail of the trial step having been taken. The negative aspect will be that all irrelevant things as well get attached with the records, and those irrelevant aspects will consume much of the energy, much of the time, and that in a way will be a hindrance in the expeditious trial. The valuable time of the court, valuable time of the system will be diverted towards many highly irrelevant situations standing caused naturally or in a planned manner by any of the good intentioned citizens or by the mischievous individuals. To draw a balance between these two extreme situations is at present a challenge. The challenge is at this stage as it is also deserves to be analyzed from many other points of view as well. And one of that will be the economics part. The second will be the functional reality. The economics in itself is a very relevant factor to be considered, as litigation already is very costly. The state resources as these are may not permit us to have heavy exchequer burden for this new experimental ideas. The practical limitations, the functional reality, the dependence upon the instruments as such as well are to be considered to have this proceedings on camera in courts experiment. In this context, when the efficacy of the virtual hearings is appreciated, it appears to be a very smart move, as the individual litigants and lawyers in a way can participate while remaining present in their own homes and offices. This smart move is proving to be handy and expeditious. And in this move, when there are virtual hearings, that means the aspect of having record of the proceedings on camera as well is inherently coming in play. Now, here again, the basic question which comes to forefront is that if the record of such virtual hearings are to be considered, particularly in situations of conflict regarding the correctness, etc., of such records, the same is going to be posed as one of the very complex legal questions. Once the records of the virtual proceedings gives rise to correctness or otherwise aspect, then it will become a factual question as well as a legal question. So this as a question of fact and this as a question of law, as we know, like all other questions of facts and questions of law, will have their direct bearing upon the adjudication. Such new facts and such new legal questions will, in a way, it can be said, are going to make adjudication to be more complex. The original basic questions of facts and law on which the parties come to a court and to which the courts adjudicate to reach at the substantive justice will, in a way, will get diverted. Therefore, the whole question of new norms of virtual hearings inherently gets linked with the concept of camera proceedings, proceedings on cameras, proceedings within cameras, cameras in courts. So we as lawyers are immediately highly concerned with it. We as students of law, we as such scholars, we as the individuals having urge to understand and imbibe the jurisprudential values of the justice systems as well are highly concerned, and so we have to remain focused about these new norm challenges confronting us, and for it, naturally, very serious, in-depth consideration is to be given, and we have to reach at a solution. The solution of this new norm requires immediate attention. Justice S.D. Anand in his books have pointed out about this new norms. The challenges of these new norms as such are not discussed in great details, but indications are that we are entering this new era of these new norms of cameras in courts. The pre-corona times ideas of cameras in courts essentially had the foundational base that the court environment shall be under continuous vigilance eyes so that there is not any diversion from the established norms of procedural conduct, etc., etc. However, with the corona situation, the necessity of the virtual proceedings has great acceptance. With this acceptance of the virtual hearings, the challenges of the record of the proceedings on camera get focused. What changes deserve to be made? What changes shall be made in our code of civil and criminal procedures to make specific as to the legal implications of such records, how these records are to be recorded, how these records are to be maintained, how these records are to be interpreted, how these records will be of equal status of other record of the judicial individual case files. Particularly, the recording of evidence is one aspect, and this record is going to have most intimate implications as the demeanors of witnesses or legal records. It is legal necessity, it is legal responsibility, it is legal requirement that demeanors of the witnesses are to be recorded. It is part of the evidence itself. And once it is part of the evidence, then it becomes essential part of the judicial record. Once it is essential part of the judicial record as much as being part of the evidence, then naturally, as the whole adjudication is to be in terms of the evidence, so this as evidence is going to become a central issue whose determination is naturally going to cause much deeper implications. Therefore, let us attend to this situation. Let us think about it. Let us research about it. Let us try to have a fair idea of all these legal questions which are going to confront us because of this new norms of virtual hearings and connected aspects of the cameras in courts, proceedings in camera, proceedings on camera, proceedings within camera. Thank you very much.